versus Martha Jane Durocher.
Good morning.
Good morning, Your Honors. Rob Wagonshoots,
Mr. Wagonshoot.
Murray County Bar, for the appellant, Martha Durocher. I would like to reserve Judge Easter 5 minutes approximately for rebuttal.
5 minutes. Yes, sir.
Mr. Rocher's case is before the court where she was convicted of reckless endangerment with a weapon after a bench trial in Murray County. Mr. Rocher is asking this court to vacate her conviction as no rational trier of fact could have found her guilty beyond a reasonable doubt of reckless endangerment with a weapon. What got Miss Newell lives across the street from Mr. Rocher on Wheeler Drive in Columbia, Tennessee. Their houses are directly across the street from each other. Miss Newell heard gunshots, but she never saw a gun being fired. At some point after the last shot, she zeroed in on Mr. Rocher's residence and saw a rifle horizontal to the ground, but not who was holding it, just 2/3 of the rifle sticking out of the back door as it then went into the home. She never actually saw the gun being fired, didn't see any pedestrians on the street anywhere around, no motorists or anybody else at all at the time of hearing the shots. After the last shot was fired, she saw that it was horizontal. The rifle was not pointed in her direction. After reading the state's brief, I think the state applied that the fact was that Miss Newell saw the gun pointed at Miss Newell's backyard. And after reading the transcripts, I could see where the state might see that in a few spots, but that's not what came out at trial. Directly behind Mr. Rocher's house is a steep hill going up Wheeler Drive. At the top of that end of her yard is a wood privacy fence. And above that privacy fence is another big 2-story single-family dwelling. The testimony that the officers testified to, and Miss Newell, that you go over that hill, which is one house up, and it goes down into Murray County Park, Woodland Park. The police shows up. They got the call from Miss Newell. They don't remember where they were at the time they got the call, but they had to then drive to Mr. Rocher's house, engage with Mr. Rocher briefly, and then Officer Wyrick was told to go down into the park, make sure nobody's hurt in the park. He drives to the park. He sees some people in the park, but he doesn't stop to ascertain were they in the park at the time of the shooting. We don't know if there was anybody in the park.
How much time passed between the time of the shots and the officer showing up to go to the park to see if anybody was there?
The officer could not testify as to exactly how much time he couldn't remember.
Okay.
From the time of the incident to the time it went to trial, he could not recall where he was at in the city, but that he was not in the park, and he did not hear any gunshots at that time.
But I'm sorry.
No, go ahead.
But the officers did testify, though, that they did not have any evidence that there were people in the park at the time the shots were fired.
Correct.
So irrespective maybe of how long it took them to get there, where people are there at the time the shots are fired, there's no proof in the record that there was anyone at the park. Is that correct?
Yes, Judge.
How
Did
far?
mi-
Oh, go ahead.
Did Miss Newell testify about how much time passed between her hearing the shots and the officer showing up?
I don't think that came out at trial as to how much time she and her family was home, her husband, her mother, her children, they were homeschooling kids. They all took cover in other rooms away from windows.
But in any event, to Judge Greenhold's point, the record's clear. When the officers went to the park, no one was there.
No, the record's clear. When the officers went to the park sometime after the shooting, there were people there.
Okay.
Right.
But they testified that they, in fact, do not know if there were people in the park at the time, which could have been remedied if the officers would have just stopped and said, hey, you all hear some gunshots? Everybody okay? And if they said, yeah, we were on the playground and we heard some shots, I don't know what that was all about.
So there was no testimony from anyone that could be considered in the zone of danger then?
Correct.
Except possibly Ms. Newell.
And yes, Judge, and I'll get to Miss Newell being in the zone of danger The court did find that Miss Newell was in the zone of danger. However, the court did make the note that when the court was 14 years old, it looked at a box of 22 shells and it said that they were dangerous up to a mile. And it seemed like the court affixed this 300-yard circumference around Miss Durocher's house that Miss Newell would have been in. But from the vantage point of Miss Newell, she was at about a 90-degree angle. When she saw the rifle sticking out of the back door, she was directly across the street this way. And the gun goes straight back into the house. The gun's never in her direction.
Well, she doesn't know because she didn't see what happened up until she saw the gun being pulled back into the house. And her testimony, if I remember correctly, was when she heard the shooting, she was terrified, the kids were terrified, and they all took cover in the house, if I remember her testimony.
Yes, Judge.
Yeah, but she didn't see the gun until the last shot had been fired, and she saw the gun being pulled back into the house.
Correct.
So she didn't know which way the gun was pointing, other than it was parallel to the ground when it was being taken back into the house.
Yes, Your Honor.
All right.
And
Let me ask you, I meant to ask this right out of the gate. The state seems to indicate this was a jury trial. This was a bench trial, wasn't it?
this was a bench trial.
Okay, I thought in their brief they said something about a petty jury, but anyway, this was a bench trial. This was just to the judge, and it was the judge who just entered this theory about the bullets he saw when he was 14.
Yes, Judge. And
There was no proof of how far these types of bullets will travel.
the only proof that came out, or the only testimony that came out, was the detective testified that he used that same caliber bullet in a deer rifle and has killed a deer up to 100 yards away with it. So
Was it up to 100 or up to 3? I thought it was 300.
I thought the testimony from the detective was 100 yards, that he's killed a deer at 100 yards with it.
Okay.
There was some testimony about 300 yards.
Yeah, I thought he,
And
well,
I may be mistaken on that point.
well, that's okay. I mean, was the detective, is he testifying as to the effective range or the maximum range?
He was
I guess that's an effective range
an
as it
effective
goes?
range that-
How far away is the park?
The park was approximately, the testimony that came out is a train tracks. There was some squealing in one of the videos that we wanted to know what that was, and the officer testified that it was a train track. There's about a half a mile away that borders the back side of the park. So
So the park was within 500 yards.
within a half mile,
Yeah.
Well, half a mile would be 880 yards, twice the effective range.
correct.
Yeah, I thought I saw somewhere in the record, though, that the park was maybe under a quarter of a mile, like maybe 0.17 or something.
Well, from where this incident occurred, the train tracks would have been about a half a mile this way.
But that was beyond the
That
park.
was on the back edge of the park from where we're at. So the park actually extends this way towards Mr. Rocher's house. But again, there's a hill that goes up, and so if Mr. Rocher was firing horizontal out of her back door as such,
Sure, she would strike the ground on the
it would
hill.
have been striking the ground. And the officers, we went to great lengths to question the officers. They never found where these bullets landed. There was no bullet holes in the ground. There was no bullet holes in the privacy fence. There were no bullet holes in the house above. There were no bullet holes, absolutely no bullet holes in Miss Newell's property anywhere.
So what was, and the thing that I can't figure out, maybe from the record, but maybe you could shed some light on it. What is the why? Why is this happening? Why is the defendant capping off some 15 rounds out of an SKS?
Well, that part never came out, and
I mean, it
As
maybe helps
why
inform
is-
maybe the mens rea or the recklessness, but I mean, is there no proof in the record as to the why?
no, the defendant just elected not to take the stand and
Okay.
testify at all.
No, and that's fine. I just was wondering about what the state of the record is in terms of the motive. Okay.
Does the record contain exhibits that are going to show us exactly what this hill and fence line and the direction that the shots were fired? Are there photographs or videos in the record?
Well, there are exhibits in the record of so some of the hill is sort of hard to tell by looking at photographs, the actual steepness of the hill, as to what it really is. But there are pictures in the record of the area. The police were never able to determine at what trajectory the bullets were fired. Nobody knows. Ms. Newell doesn't know. The police don't know. They never found evidence of of where these bullets landed, so we don't know. And if with the bullets are going over the hill, they, based on, I mean, there was no, it would have gone over the park anyway, if it would have gone over the hill. And if it didn't hit the fence and it didn't hit the house, and it set a trajectory so high, it would have sailed over the park.
Depending on the range.
Depending on the range.
Oh,
But we don't know. There was never any proof in the record as to what goes up went down as dangerous as it was. I mean,
Okay, so the record identifies 3 houses in between the defendant's house and the park. Any proof that anyone is at home in those
no
houses?
proof. The officers didn't go to any of the homes to ask if anybody was home, didn't ascertain if anybody was in any of those houses. The only place that was absolutely occupied is Miss Newell, who was across the street 90 degrees from where they're suspecting that this gun's being fired. The court did apply that the zone of danger was anywhere that any of these projectiles would have gone, and they would have traveled well in excess of 300 yards. Well, we don't know where they went, so I would have argued that the court did apply what would be the zone of danger. The problem is wherever that zone of danger is at never came out in trial. We don't know where that was at to even tell if anybody was there or not. There'd be nothing further. That's all.
That really is, that's the only issue you're raising, is the sufficiency specifically as it relates to the zone of danger element.
Yeah, yes, Your Honor. The zone of danger is absolutely wherever it was at. It was never brought out at trial where that zone of danger actually is. And the fact that the Newells were scared doesn't mean that they were actually in the zone of danger just because they were scared.
Why are you not relying on Rimmel? I mean, neither party cites Rimmel, and I don't understand why,
Well, and
why
that's
that is.
what
What's the reason?
And
I mean, I was on the Rimmel panel on this court. I mean, what was
I wrote the room.
I wasn't going to say it. But
and
I mean, the panel in Rimmel, this court found that reckless endangerment was appropriate, supported by the sufficiency of the evidence. The Supreme Court disagreed, finding that there was no evidence that the weapon had been pointed at the driver of the car. In fact, may have been pointed away. It seems to be, the Supreme Court's holding seems to be relevant to this case. Why are you not citing Rimmel?
well, and Judge, I did have Rimmel written down. I wrote it down in my notes after I had submitted my brief. It was a newer case when I was preparing for my brief. It's very much like this case where in Rimmel, the woman in the car did not ever see the gun pointed at her. Nobody ever said that the gun was pointed at her. However, that gun was never fired, where in this case, a gun was fired. And I felt like the evidence deduced at trial that State v. Fox was very much on point, where if the gun had been fired horizontal in any direction, it would have most definitely hit houses, trees, fences, the ground. And the police, the way that they did their investigation, they would have found that evidence to support that it was held in a horizontal trajectory.
But I think the Supreme Court's opinion, like I said, different from the opinion that the panel had, but I think and its opinion obviously governs. The Supreme Court's opinion, I think, is that if the weapon isn't pointed at the victim, then there can't be reckless endangerment. And so if it's pointed away from the victim, even had it been discharged, I think our panel thought that if you're banging that gun against the window as it was, it could discharge. The Supreme Court, I think, said even if that were the case, it was pointed away and so therefore could not constitute reckless endangerment. Seems to be at least relevant here, and that's why I was wondering.
It is, Judge, and I had it in my notes to hit, and I neglected to cite that. And I relied on Fox at trial, and the trial judge acknowledged Fox. His opinion was that the higher courts got it wrong in Fox because what goes up must come down. I think that theory has been not accepted on several other cases, that what goes up, there was no evidence in this case submitted that the bullets, when they were fired up, would have been dangerous when they came down. That never came out at trial, which is relevant as well. And the state could have called those experts, and they chose not to.
Okay.
You still have your rebuttal time.
Thank you, Your Honors.
General Ball? Does what go up must come down?
That's right, Your Honor. Good morning.
All right.
May it please the court, Ben Ball on behalf of the state. Here, the defendant contends the evidence was insufficient to show that anyone was in the zone of danger here. And it's the state's position that the state did establish that there were people, that there
Well,
was
let
a
me
zone
ask
of
you,
danger and there were people in it.
Is it, or was it the state's theory ever at trial that Miss Newell and her folks were in the zone of danger?
So I understand the state's theory at trial to be based largely on Woodland Park. I did read the record, and admittedly it's a cold record. I did read it to suggest that the gun, the path of the bullet would have been across Miss Newell's home.
So your answer is no, it was never the state's theory. Or
No, I think that's right. I mean,
I have to be
it's-
honest. I don't read the record to be that the state was
it was
arguing that.
always the state's theory. It was the folks in the park.
It was the park. I think the trial court certainly read it that way. The way I read the record supports the trial court's interpretation. And apologies for referencing in my brief the Pettit jury. That was a mistake.
That's fine. Yeah.
And I probably should have filed a motion to correct. But I certainly read the record that way. It's a little unusual situation that I have some actual also knowledge of the area. I grew up in Columbia and have attended countless events in Woodland Park. But the record suggests that is the lineup. But what we have here is the defendant fires this, and I want to take issue a little bit with the idea that Miss Newell did not see the weapon fire. What Miss Newell specifically testified was that she saw the barrel of the rifle pointed horizontally as the last round sounded. So concurrent with the last shot, or at least her hearing of the last shot, which I take to be fairly concurrent. This bullet was fired about the time she saw it, and then the rifle withdrew. So she
did not see smoke emanating from the rifle, though.
She didn't.
Is that
She did
right?
not. She did
Okay.
not
And I don't know about the Soviet SKS and whether it emits smoke when it's fired, but I think she was asked about that specifically, right?
I believe she was, and I believe that's correct. But she also described it as sounding the last shot concurrent with her seeing it, and it's up to the trial judge at the trier fact to.
And so that
all
sole
of that.
proof then, I mean, the proof, without bordering into speculation or conjecture, the sole proof, though, is that the weapon is pointed away from her. So is there anything then in the record that would establish that the weapon had been pointed toward her house in the direction of her house rather than perpendicular to her house? Because if I'm right about what Rimmel, the Supreme Court's decision, was holding, I think we're going to have some evidence in the record, not speculation, but some evidence in the record that the weapon was pointed in her direction.
And to be clear, that is not what we were arguing in our. I mean, I know that as I've written the facts, it indicates that, but.
Okay, so back to Judge Easter's question then. I mean, Miss Newell is off the table then as far as the state's argument here about her being in the zone of danger.
So we're talking about
Only
Woodland Park.
Focus Park. Oh,
And this is and this is one reason I didn't get into Rimmer in my brief, was that this is not a situation where I'm trying to argue that someone who was not in the path of the gun.
Okay, that's a helpful concession.
So because what we have here is we do have testimony about the direction of this being fired. Woodland Park is approximately, they describe it sort of 3 yards away. Now the playground is a little farther. I think it is towards the back of the park. The back end of the park is a full half mile away. And then what we have as far as testimony about the rifle itself. I can acknowledge it would have been helpful to have testimony about the precise range of the rifle. What we have here is Detective, I believe it's Stanage. He testifies that he himself has fired this rifle, and he finds himself accurate with it from 300 yards. Not that the range, this is where he is still accurate. So I think it is a reasonable inference, not speculation, then to say that the total range of that rifle is farther.
But how much further is speculation, right, on this record?
Well, 300 yards alone would get us into Woodland Park, and it wouldn't take.
Would it, though? Because, I mean, if we're talking about that it's a quarter of a mile away, that's 440 yards. If we're talking that it's half a mile away, it's 880 yards.
So
that 300
right.
yards doesn't get us there.
880 yards would be the back part of the park.
Where the playground is?
It's much less than 300 to the front part of it, and then the playground is somewhere in between that. I don't know that we could.
It may be more than twice the effective range as testified to by the officer.
880 yards would be more than twice the range for his personal accuracy.
For the record, for the range established by the record.
Well, to be clear, what he says, he doesn't say that is the total range of that rifle. He says that is the distance from which I am accurate.
Okay, but the record otherwise has no indication about either what the effective range is or what the maximum range is, so that's really the only proof the record has, right?
That is correct, and obviously that testimony would have, expert testimony on the capabilities of the rifle certainly would have been helpful here, but I don't think we're moving into the realm of speculation to say that this rifle was capable of reaching into Woodland Park and into the playground. We also have we established that there a short time, and we don't know the precise time, I have to concede that. I believe this officer's testimony tends to indicate that it's talking more in terms of minutes, not hours. They arrive, shortly after this shooting, and then after arriving at the scene, they immediately go to Woodland Park, and they see people at the park. Now, would it have been helpful to have surveillance video from the park from the time, or as your honors mentioned, someone who was at the park testified they were there? Absolutely, but I think it is a reasonable inference. This happens in the middle of the day. They've established there were people there shortly after. I think it was a reasonable inference that this park had people in it within the zone of danger.
So it would be reasonable, right, if we had timing. It would be reasonable if we had someone testify about it. What the record has, though, is an absence of timing. How long did it take the officers to get to the defendant's house? How long did it take them to interview? How long were they dispatched then to the park? What we also have is an absence of anyone in the park offering any proof at all. So, I mean, where is the reasonable inference being drawn from?
And an absence of how far these bullets actually
Right,
can
the range,
travel.
the range, right.
Question.
Oh, I mean, I agree with you, Your Honors, that is definitely sort of the inflection point of this case, is the trajectory / distance of the bullet's path, and then the people in the park.
And you're not doing this today, and I don't ever suspect that you are doing this, but the line sometimes between reasonable inference and speculation concerns me, and I wonder about how close we are to reasonable inference, and actually maybe more closer to just speculation or conjecture.
So I mean, I have to acknowledge, Your Honor, that this case draws closer to the line than many. It certainly makes it a little harder to defend, but I don't think it crosses that line into speculation.
Is it concerning for the state, the trial judge's speculation about this box of shells that he saw when he was 14?
So,
what do you make of that?
I'm not quite sure what the trial court was getting at by that. I didn't read it that he was using his personal knowledge of the ammunition to establish the range. I took it as a bit of a just loose reference. I think he did, if I recall, I think the only evidence we have about, and I don't want to call it range because it's not the range of the gun, it's just the distance from which this detective felt that he could shoot accurately. But that was really the only thing we had about it. And I don't recall that the trial judge's sort of recollection of his childhood experience with these rounds.
Where does that come in that statement? Does it come as he's deliberating on whether or not the defendant's guilty or not? Do you recall?
It eludes me, Your Honor.
Okay.
I apologize.
I thought it came when he was explaining the verdict.
I think that's correct, Your Honor.
And I took it to mean, and again, it's all subject to speculation, unfortunately, but the fact that, well, if a 22 goes a mile, then 7.62 by 39 is going to go a mile or maybe more. That's the impression I got from.
I mean, there was some. I think what he was saying to some degree is that sort of common sense dictates, and I think that this maybe sort of is where we draw the line between inference and speculation.
I mean, that's exactly the kind of thing we tell jurors not to do when they're back there deliberating, is to speculate about, well, I shot a gun when I was 14, or I saw a pack of bullets when I was 14. I mean,
we tell them not to speculate, but they can make reasonable inferences. And I mean, I think it is, we live in a state where a lot of people own and use firearms. And I think given the testimony
But if that were introduced into deliberations, maybe harkening back to our first case, that's extraneous information, right? If a juror came in and said, look, I fired this gun all the time, it's got a maximum range of 2 miles.
So to be clear, I'm not saying that had the judge said, I know this is the range of this, and so this is, that would have been, if there was some sort of transitive property going on there. That's not what I'm suggesting happened, or the scenario you proposed where the jurors are, though I suspect that probably does happen all
It
the
might,
time.
and we're not going there, obviously, but
what I'm getting
we're
at
just talking
here-
about what's in the record and what you can draw an inference from.
What I'm saying is you can use your common sense, your reason to make these inferences, and when you have a detective who is talking about his ability to fire accurately from 300 yards with this, what is essentially an assault-style rifle, I think it is reasonable to extrapolate from that the gun can fire significantly longer range. And obviously, we can only extrapolate so far. I mean, we were talking about a case where Woodland Park is 2 miles away.
So help me with this then. Help me about the trajectory. So your friend on the other side says, we're on a pretty steep hill here. We're on an incline. And in fact, if you're firing horizontally, as Ms. Newell testifies that she saw the weapon, maybe perhaps being discharged at the end, you're going to hit the ground. You're not even going to clear the hill. And so the rounds themselves aren't going to be able to go over the hill and into the park itself. No proof of they say, no proof of anyone else in the houses in between. So help me with the trajectory. Is it almost just pure speculation at that point that the trajectory of the bullet had to have been at such an angle that it would have cleared the top of the hill and then landed in the park afterwards?
Your Honor, I would say that I don't know that the record bears out the idea of this hill as a sort of a complete barrier that would have taken a arcing shot to get over.
But a horizontal shot would not have, and we agree with that.
I'm sorry, Your Honor.
So, but a horizontal shot would not have, and we agree with that, right?
I'm not sure the record bears that out either exactly. I mean, I have to acknowledge that this is, the neighborhood this is called Rolling Fields. I mean, it is a hilly area, but I don't think the record bears out that there would have been a blockage necessarily. And again, I think horizontally is used here to describe generally that the gun is not vertical. I don't think it means that it is perfectly perpendicular to the ground.
Well, the thing is, though, and again, based on the police testimony, there are no holes in the fence. There's no holes in the house behind the fence. And I think trying to find a bullet hole in the ground is almost impossible unless you have a metal detector or something like that. So at least, I guess, the immediate elevated area, the fence and the house, there are no bullet holes.
That's right.
So you would think then that the gun would have to be pointed a little higher to clear all that, or you would at least find a hole somewhere.
I think that's right. I mean, and we're talking about pretty, small degrees of difference in how the barrel would have to be pointed, any of which could be perceived as horizontal by someone looking from across the street. I think it is probably overly literal to read it as exactly horizontal. And I think given...
Once again, the difference between reasonable inference from facts and speculation.
I think this was a reasonable inference that the gun was pointed towards Woodland Park at an angle that could have allowed it to reach it. And again, we're talking about a zone of danger. It's not a line of danger. I don't think that the law requires us to establish the precise track of the bullet. And
Rimmel gets us closer to that, though, doesn't it? So Rimmel, I think, says if it's not pointed in the general direction of the victim, it's not reckless endangerment.
It does say that, and the state's response to this is pointed in the general direction of victims. Okay. Rimmel says that if your gun is pointed straight ahead, that my friend on the other side is not in the zone of danger. The people here in the gallery are not in the zone of danger. The three of you, would be in the zone of danger.
Because I think this panel would have held that in Rimmel they would have been in the zone of danger, and I think if that holding had prevailed, I think there might be a better argument here. But with Rimmel's restriction on that, I wonder about how far it goes.
Well, of course, Your Honor, Rimmel involved a gun that was not fired as well. So I mean, I think in Rimmel
By luck.
Absolutely, but I mean Rimmel, we're talking not about the path of a bullet, but about the potential path of a bullet. So there, Rimmel definitely opens up, the scenario in Rimmel opens up, I think, much more danger of speculation. Here we're talking about a zone, and I think anytime you imagine the barrel of a firearm, we sort of envision extending outwards in two diagonal lines. There's a zone created by it. It's not necessarily a direct line that is the size of a bullet that someone must be standing.
And you're saying that the record establishes sufficiently that there were people in that cone of the zone of danger at the time of the shooting?
I think there's sufficient circumstantial evidence of it. We don't have direct evidence, as I've acknowledged. We don't have a video from the park. None of these people come in and testify, but I think given that within a brief time after the shooting, there were people in the park, and the shooting took place in the middle of the day. I think that is a reasonable inference for a trier of fact to make. The same way I think is reasonable for the trier of fact to infer that the ammunition from this SKS could have reached well into the park and created a reasonable probability of death or serious bodily injury to one of the occupants. And that's all the state had to show there.
Anything else?
Okay, thank you.
So if there are
Thank
no
you.
further questions, I
Thank
would
you.
ask this court to affirm the judgment of the trial court. Thank you, Your Honors.
Thank you.
Thank you, General Ball. Mr. Wagenschutz?
Again, the facts of this case, in order to find Mr. Durocher guilty beyond a reasonable doubt, is asking the trier of the fact to speculate a lot of things. I'm not here to say that Detective Stanich was in any way untruthful in what he said, but I've known a lot of hunters and fishermen in my life, and we've all killed a deer pretty far out there. And I don't know that there's any real evidence in the case and presented to show what well, there was no evidence to show what kind of round was Detective Stanich using when he shot that deer, because that does matter. The type of round, the amount of powder in that round, whether it's a hollow point, whether it's a full metal jacket, all of those things matter as to how far the maximum effective range of a round is. None of that was fleshed out in trial. The state could have got an expert. They found rounds that were in the rifle that they seized, so they knew generally the brand and the type of projectile that was in there, that they could have fleshed that out, but they chose not to. They would just rather everyone speculate that, oh yes, it was fired horizontal. No one actually saw it being fired. Shortly thereafter, Miss Newell saw the gun being horizontal, but I mean, bang, like how long does it take to go from a firing position, bang, to horizontal? It's just a fraction of a second. And so how much time does it take for Miss Newell to, from the time she hears the last shot to the time that she affixes her sight line of sight on the back of Mr. Durocher's residence? Even if it's 2 seconds, what she saw may not have been where the rifle was at the time of it firing. Again, we don't know where the rounds went, and wherever those rounds did go, that's where we would have to say, was there anybody in that area, and were they in the zone of danger? The playground, the park, that park is very wide open. There's a disc golf course there. There's not playground there. There's a lot of just open land of the park. There's no evidence that that those bullets, if they did go into the park, assuming they did, that it went anywhere near where the playground was at or the pavilion where the officer saw somebody. And again, the officer could have fixed that by saying, hey, did you guys hear those shots? Everybody okay? And that we would have known at that point if they were there or not. So, thank you, Your Honors.
Thank you, sir. Thank you both. We will take the matter under advisement and issue an opinion straightway. All right, we're going to take a 10-minute recess, if you'll bear with. 10 minutes will be fine. 10-minute recess, and then we'll come back and hear the final oral arguments